to start by defining law briefly. These lectures are very basic and normally given in the first week of your course, so I'm going right back to the beginnings. Law, according to Hobel, H-O-E-B-E-L, a social norm is legal if its neglect or infraction is regularly met in threat or in fact by the application of physical force by an individual or group possessing the socially recognized right of so acting. That's the definition of law. A social norm is legal if its neglect or infraction is regularly met in threat or in fact by the application of physical force by an individual or group possessing the socially recognized right of so acting. That's from Hobel's Primitive Law, or words to that effect, 1954, page 28. In such a definition, many societies don't have law with a capital L. For example, Evans Pritchard says, in the strict sense of the word, the Noah have no law. Law is a cultural construct of civilization, and 90% of human history, people didn't have law in this sense of having institutions to affect it by a group possessing the socially recognized right of so acting. Law, according to Hobel, has four main functions. One, to identify acceptable lines of behavior for inclusion in the culture. Secondly, to allocate authority and to determine who may legitimately apply force. Three, to settle trouble cases. And four, to redefine relationships as the conditions of life change. Law is often divided into two levels. There are rules, and there are rules about rules. This is taken from the legal theorist H.L. Hart. There are the rules themselves, like thou shalt not murder, or thou shalt not steal, or whatever it is the rule is. And then there are rules for applying the rules. How do you decide if someone is guilty of murder or stealing, and so on. So there are two levels. Now the great problem in anthropology is how you approach the vast diversity of legal systems in history and cultures. How can you get a framework which will deal with all the different types of legal situation that you find in everything from hunter-gatherer groups to great civilizations like America or Russia or whatever. Here there's the usual tension that is current in all anthropology. That is between formalist, that is, by now I hope you know the difference between formalist and substantivist. Basically formalists are taking models from your own society, Western societies, applying them in economics or any other sphere to other societies, or substantivist, that is looking at the substance of the society without applying your own legal frameworks or economic frameworks to them. Now, this is particularly marked in legal anthropology because of the highly elaborated analysis of law that has gone on in the West for the last 2,000 years since the Romans. As Gluckman, who is a major theorist here, admits, that's G-L-U-C-K, well you should know how to spell Gluckman now. In analysing legal problems in an African society, one has to use terms and concepts which have been employed by jurists through 2 millennia. Or as Bohannon, B-O-H-A-N-N-A-N, or sometimes in American O-N, writes, because of its tremendous field of assumptions and undefined premises, law probably has one of the most extensive foundations of ethnocentric metaphysic of any discipline. So, how do you solve this? Well, the great dispute between Gluckman and Bohannon, about which we'll hear probably more, is that Bohannon thought he was a substantivist in this sense. He thought, for instance, I consider it to be the cardinal error of ethnographic and social analysis, the grossly ethnocentric practice of raising folk systems, like the law, designed for social action in one's own society, to the status of an analytical system, applying one's own folk system elsewhere, whereas Gluckman, who was trained in law, believed that you could use Western legal concepts to analyse legal systems wherever you encountered them. How do we solve this dilemma? Well, one approach is to distinguish firmly between folk, that's what used to be called emic, as in phonemic, and analytic or etic systems. And Bohannon stressed the need to separate these off. We need some higher system above our folk systems in order to compare. It's something that Edmund Leach suggested in relation to kinship systems, that you try and find some universal higher level. He suggested mathematics for getting over the problems of defining things like marriage, the family, father, and so on. But in fact, Bohannon suggested a three-level system, which I think is quite, at least it makes explicit the difficulty. You have a comparative framework, which is developed by analysts like ourselves. And then you look at different legal traditions, and you notice that they themselves have two levels. They have the Tiv, who are in African societies studied by Bohannon. They have their folk system, and the Barotse, who are studied by Gluckman, have their folk system. And what is a bit shocking to us, we have the Anglo-American, i.e. all our legal systems in the West, in America and England, folk system, what you see in our courts of law here. And we have our the Roman law, which is the one that prevailed over the continent for several thousand years, folk system. They're no better or worse than each other, they're just folk systems, internal. But above them, you have Tiv analysis. They think about their folk system, they analyse it, they can specify it. And you have the same thing, you have Barotse analysis, you have legal analysis in Anglo-American law, and you have Roman jurisprudence. The argument really is that, to a certain extent, Gluckman believes that you can use the Roman jurisprudence and legal realism, as it's called, of Anglo-American law, to analyse the Tiv and the Barotse, whereas Bohannon thinks that these are just analyses of particular systems, and you need to take out of this and bring up to a higher level concepts which will then allow you to look at this analysis as just local. When this schema was devised in a conference in the 1950s, 60s, it was thought that it resolved the Gluckman-Bohannon dispute and the dispute between substantive and formalist approaches. And it's, to a certain extent, it does, but doubts remain in my mind anyway. Who is to judge what is valid to draw up into the top box? How do we reduce the colouring of words, which is always the problem in anthropology, the heavy semantic load of words like property, crime, sin, even murder, certainly truth. Many of these things, terms that you use, are bundles, have bundles of meanings which, if you take them out of a particular context and move them up into a comparative frame, you have to redefine them all, and they don't overlap in different societies and civilizations. But perhaps it's the best we can do. What this box does is to translate between systems. This is the big problem in anthropology, how you translate between even French and English, let alone between Japanese and Western legal systems. And it does make you aware of the danger of imposing your own legal concepts and warping another culture's ideas. I don't particularly agree with Gluckman. Gluckman's argument was that we have the most sophisticated system. Look, we've been thinking about it very carefully for 2,000 years. The Romans were great lawyers. We've had great lawyers since. We had paper, we had machinery, we had courts. Therefore, we have much more experience, and we can think about things, and we have made distinctions which other societies haven't. If you looked at TIV analysis, you'll find that many of the concepts which have been elaborated and developed over the last 2,000 years are not there in the TIV. It's rather like you encounter the same thing in translation of languages. There are many words or many concepts which, for instance, in Gaelic, in the Scottish language, you didn't have a word for computer, you didn't have a word for electricity, you didn't have a word for this, that, and the other thing, because they weren't there in traditional Gaelic society. So Gaelic language had to incorporate all sorts of loan words from other cultures and concepts, philosophical concepts and so on. And this is the same problem here. And it was the same in Japan, lots of Western concepts. The very concept of right, which is central to law, had to be invented in late 19th century law. We had an expert sitting with us here who's looked at these sorts of things, but it was Fukuzawa Yukichi who brought in the Western, invented a term for right in Japan, because it wasn't present in Japanese law before that. So there are, I don't think that this solution of just taking Western legal reasoning over the centuries solves the problem, but it does, this thinking about this does alert you to the heavy ethnocentric bias of many legal analyses, as it does in economics or politics. Another approach is to look at the question in terms of some basic motivation or model of human beings. In economics is founded on the proposition that we all act rationally to maximize our gains from transactions with each other. Without this, economics collapses. And it was thought that maybe you could take the same approach in law, that you could find some basic human attitude which would then underpin all legal systems. And the one that Gluckman thought he found was the reasonable man. He says the reasonable man is recognized as the central figure in all developed systems of law. And if it can be found everywhere, he thought he found it in the Lozi and the Barotse where he worked in Africa, if it can be found everywhere, that all legal systems have the reasonable man, then it acts rather like the exchanging man or the power-seeking man in politics. Gluckman said, took his idea from someone called A.P. Herbert, whose book Uncommon Law is a delightful introduction to the paradoxes of English law, as in the Haddon. In the first essay, which is called The Reasonable Man, he tells the story. I won't go into it in detail now because we're short of time, but basically he tells the story of a gentleman whose punt was sunk by a lady who was going past in a speedboat, and he's defended by, the lady is defended by Herbert's famous defence lawyer, Sir Ethelred Rutt, who argues that the whole of English law is based on the concept of the reasonable man. It's someone who is an ideal, a standard, the embodiment of all those qualities which we demand of a good citizen, no matter what may be the particular department of human life which falls to be considered in these courts. Sooner or later we have to face the question, was this or was it not the conduct of a reasonable man? Did people take sufficient care, etc., etc.? the reasonable man is a careful, organised, devoid, in short, of any human weakness, with not one single vice, sans prejudice, procrastination, ill nature, avarice, and absence of any kind, as careful for his own safety as he is for that of the others. This excellent but odious character stands like a monument in our courts of justice. This reasonable man is personified by the jury, who on taking their oath become 12 reasonable men. Now the twist that Herbert gives to this is that at the end, after all this, Sir Ethelred turns to the judge and says, "My lord, the defendant, my client, should be acquitted. She's a woman." There is no mention in any of this of women. It's all about reasonable men. She can do what she likes, and that's the end of it. The point, of course, is that it's a universalistic solution. Within men is encompassed, unfortunately, women as well, rather than having to say it each time. Now, there are one or two features about this which are worth just stressing. There's an emphasis on citizenship. All people are men, women, and so on. The behaviour is universalistic. It's not specific to age or anything else. It's not distinguished by role or status. Rich, poor, old, young, male, female are all meant to be reasonable people. Of course, the contents of what is reasonable is very culture specific, but the standard is meant to be universalistic. And finally, the purpose of this is not to use it as a way of judging evidence or cross-examining, but rather as a way of allocating responsibility. Was it reasonable for someone to bring an action against the county council for slipping on ice because they hadn't cleared it, or should they have taken more care, that sort of thing. When Gluckman uses this in his ethnography of the Lozi, he uses it to show that the Lozi had the concept of the reasonable man, though they never used those words. But there are two features about it. One is that it's used to establish the truth in cross-examination. In other words, it's to detect lying. The example that sticks in my mind is if someone has got drunk, come home, found their wife with another man late at night, and she comes to court and says, "My husband beat me up and hit me," and so on and so on. And he says, "Of course I didn't hit her, I never hit my wife," etc., etc. Now, is it the reasonable behaviour of a drunken man who thinks his wife is committing adultery to hit her? I mean, it's not reasonable in the sense it's acceptable, but is it the sort of thing he would probably do? And the answer is yes, he probably would do that, and therefore he is guilty of this offence. So it's used as a forensic device to try and work out whether someone is lying or not, which is entirely different from the A.P. Herbert use of it. And secondly, as Gluckman constantly says, the reasonable man is usually implicitly present when people contrast reported behaviour with the norms of behaviour of particular positions. That's what he uses. In other words, and he gives example, the reasonable husband, the reasonable induna, I-N-D-U-N-A, that's a headman. In other words, people should be reasonable within the role and status that they occupy. So it would be reasonable for an uncle to beat his nephew, but it is not reasonable for a nephew to beat his uncle. It's reasonable for a father to beat their son, but not a son their father. It's status specific, and he again and again says this. The whole point about the English use of it in Herbert is that it's not status specific. It's not reasonable for a woman to swamp an old gentleman in a punt. It wouldn't be reasonable the other way around. It doesn't matter whether they're women or men, or old or young, or the lord of this and a taxi driver. It's just universal reasonableness. It's completely based on the lack of status. So, in fact, Gluckman's reasonable man in Africa is illustrates the total difference between African law and English law, rather than confirming what he thought was a universal principle. And this arises from perhaps the most important underlying development in the history of legal anthropology, which occurred in the 19th century. It occurred in Cambridge, in Trinity Hall, with the work of Sir Henry Maine, with an E, in his book Ancient Law, and 4 or 5 other books. And if you're interested in, I used to give a lecture on Maine, which I think is on my website, and certainly I've written a lot about Maine, which is on my website. And he is the most important legal thinker in anthropology. He was part of the great sociological breakthrough of the second half of the 19th century. Fernand Tönnies, T-O-N-N-I-E-S, from community to association, that is from Gemeinschaft to Gesellschaft. Durkheim's mechanical to organic solidarity, and Durkheim's work on law, and many others, including Maine's movement from status to contract. Basically what Maine was saying, that in almost the whole of human history until very recently, our legal relations with others have been based on family relations, on family dependency, rather than on individual relations between two separate individuals. This is what he means by status. You are born into it. Status basically means that you are born into a position. You are born as a woman, you are born as a son, you are born as a slave, and you can't change it. Status remains with you all your life. It's embedded in a relationship. And that is the condition, the substratum for all of legal relations through 90% of human history. The great movement is from those kinds of systems to those which take as the basic unit an individual who is free from status over terms. In his most famous phrase, the movement of the progressive societies has hitherto been a movement from status to contract. That's Ancient Law, page 169. From this, it can be said, he says, the society of our day is mainly distinguished from that of preceding generations by the largeness of the sphere which is occupied in it by contract. Because another way of putting this, a contract is between two free individuals. You have to have complete freedom, autonomy, equality. Otherwise, you can't have a contractual relationship. Status is inherent in your relationship. Contract is entered into freely by two people. This distinction, as all those who've worked on the history of law and legal anthropology, and even Goldman recognized this generalization is among the most important which scholars have advanced to cover a sweeping movement in human history. And I think if you use that idea, that contrast, obviously it's not a binary. We have in our legal system, as Maitland and others have pointed out, a lot of status. It's not free of status. Women are still not always treated equally. Children are often or sometimes treated as unequal to their parents, and so on. But there has been a shift along a continuum from almost pure status to a very mixed situation of status and contract. And I want to now, in the last part of the lecture, look at the consequences of this difference, which I think help a great deal. But I'll just give you a minute, as I usually do in these lectures, and then continue. Are there any questions? I want to start looking at the implications of status and contract, firstly in terms of the notion of the rule of law. You often hear politicians and others saying, we believe in the rule of law. It's not always apparent that they understand what the rule of law means. I think most of them think it means just being law-abiding, not breaking the law. The rule of law, according to Dicey, D-I-C-E-Y, in his famous study, the study of the law of the Constitution, which defines this, means the following things. Firstly, the supremacy of law in dispute settlement. He says, we mean in the first place that no man is punishable or can be lawfully made to suffer in body or goods except for a distinct breach of law established in the ordinary legal manner before the ordinary courts of the land. In this sense, the rule of law is contrasted with every system of government based on the exercise by persons in authority of wide, arbitrary or discretionary powers of constraint. In other words, Guantanamo Bay, the arbitrary imprisonment of people in many parts of the world under pressure from the fear of the war on terror and so on, is not abiding by the rule of law. Much of the rule of law has been sidelined in America and England and the West to try and deal with this apparently imminent threat. Another aspect of this is that disputes must be settled through legal channels. As Roberts, whose little book on legal anthropology is one of the best introductions, says, in its sphere, law enjoys a position of absolute supremacy. All other normative systems give way to legal rules. And the courts are ultimately the authoritative agencies of dispute settlement. So, basically, you mustn't use other mechanisms to solve disputes. You must go to law. You mustn't fight. You mustn't use physical force. You mustn't use supernatural agencies if you believe in them, like witchcraft. And even things like withdrawing reciprocity or ridicule or ostracism. You must sort out your things by talking in a court of law. Now, this isn't unique to the West. Many African societies settle most of their disputes by talking. For example, my former supervisor, Shapira, S-C-H-A-P-E-R-A, who's written a lot about African law, and particularly about the Gatla, that's K-G-A-T-L-A, South Africa, says a settlement-directed talk enjoys preeminence as a mode of handling disputes, while such means as violence, self-help and sorcery are strongly disapproved. Actually, that's summarised from Roberts, page 151. But basically, many societies, the one I worked in Nepal, you talk out disputes. You don't resort to physical violence and so on. So the legal process is completely dominant and must be open, normal, transparent, and that is the main meaning of the rule of law. The second meaning is, as Dicey says, we mean in the second place not only that with us no man is above the law, but what is a different thing, that every man, whatever be his rank or condition, is subject to the ordinary law of the realm and amenable to the jurisdiction of the ordinary tribunals. That is another nail in the coffin of detention without trial for long periods, putting people in incarceration and then not accusing them, and so on, the many things that have been happening recently. All people are accessible, have access to the same ordinary law. And thirdly, his meaning is that it's judge-made law, not a Bill of Rights. Thirdly, we may say that the Constitution is pervaded by the rule of law on the ground that the general principles of the Constitution are with us the result of judicial decisions determining the rights of private persons. It's not, we don't have a Bill of Rights, as you know, in England, and so it tends to be emerging from many, many decisions. Although recently the balance has shifted and there have been more and more legislation. In the last 10 years, there's been more legislation in this country than in the whole of the history of English society. Where did this concept of the rule of law come from? Because it is pretty unusual. One is that it's a recent product, a product of the capitalist and liberal revolutions between the 17th and 19th centuries in England and America. The turning point being the time of Locke and Jefferson and others. A more plausible view, I think, at least my view, is taken from the great legal thinker Roscoe Pound. That's Roscoe, R-O-S-C-O-E, Pound, P-O-U-N-D, who says that the concept comes from a fundamental notion of Germanic law, of which the feudal right of the relation of king and subject and the reciprocal rights and duties is an example. It became a central feature of common law from the Middle Ages and much earlier onwards, which was based on the presumption that no one is above the law. Even the king is under the law, not above the law. And this is the fundamental difference between English law and continental Roman law. In continental Roman law, l'état c'est moi, the state is me. Louis XIV's famous summary of this. I am the state, I am above, I make the laws and you obey them. In England, there is this nebulous thing called the law, under which there is the king, the crown, everything. And this is the basis of democratic societies, that the political process is under the law. It's not arbitrary, whereas in absolutist societies, the political system is above the law. The classic position in England was stated in the 13th century by a lawyer called Bracton, B-R-A-C-T-O-N, and later cited by Coke, the great common law lawyer, during the Civil War. The king is under no man, but only under God and the law. That's what Magna Carta was centrally about in 1215, and it's a crucial feature of English law, that no one is above the law. And that's why when politicians start tinkering and tampering with that idea and making executive law, it's so dangerous. If you're interested in that whole question, then Helena Kennedy's book, Just Laws, very useful on that. There are some implications of this which come back to some of the things I was saying before. One is equality before the law. In a social structure based on contractual relations, which is what capitalist individualistic societies tend to be, legal disputes are between legal equals. Whatever their relative wealth, their education, their birth and so on, they are equal. Thus, a man called Bernard Cohn, C-O-H-N, who wrote a lot about law in India and worked in India, says, basic to British law is the idea of the equality of the individual before the law. But that idea is totally against the normal situation where people are not equal before the law because they are born unequal. They're not inherently equal, either outside the court or inside it. Cohn remarks that North Indian society operates on the reverse value hypothesis. Men are not born equal, and they have widely differing inherent worth. This theme of value is basic to the whole social structure and is expressed most clearly in the caste system. In a caste society, you're not born equal. In Muslim society, Islamic society, derived from a very early period, you're not born equal. A woman is inferior to a man, inherently. And a believer is superior to a non-believer. And this leads to clashes of legal systems. As Cohn writes, when Indians go into a court, they are supposed by definition to lose their outside statuses. It is not Thakurs and Chamars, that's T-H-A-K-U-R-S, and Chamars, C-H-A-M-A-R-S, who are having a dispute, but a defendant and a complainant. The adversary system has developed to equalize the persons in court. To an Indian peasant, this is an impossible situation to understand. The Chamar knows he is not equal to the Thakur. He may want to be equal, but he knows he is not. The Thakur cannot be convinced in any way that the Chamar is his equal. But the court acts as if the parties to the dispute were equal. This is in Bohannon's Reader on Law, page 155. And this is really what comes out of the Lhotse ethnography, which is that the disputes are very often about relative status. They're not about contracts. And they start off with the presumption that the parties are not equal. So caste societies or kinship-based societies or societies which have a strong gender and age difference come and clash with those which are based on the premise of equality. Homo hierarchicus in Dumont's phrase against homo equalis, as he called it in his second book. Maine, in fact, who drafted the legal framework for modern India, he was the advisor to the Indian government in the 1850s and laid down much of modern Indian law, reported that 19th century Indians complained that life in India has become intolerable since the English criminal laws had begun to treat women and children as if they were men. Complete revolution. They were treated as if they were the same. This is intolerable. The premise of inequality, which is almost universal in human societies, is challenged by this odd, eccentric legal system that emerged on this island almost alone, and for some centuries was the only example of this, and then spread to America and is now underpins declarations of human rights and everything else. This legal system is based also on another concept, which is the idea of individual rights. As Dumont has pointed out, hierarchy and holism, which are, by holism, Dumont means something similar to hierarchy, that is that the whole or the greater unit, the group, dominate the individual, are linked to each other, just as are equality and individualism. It's another part of the same thing. Hence, inseparably linked to the idea of equality before the law is the idea of inalienable private rights or human rights. As I mentioned, Maine saw the change from family-based to individual-based laws the major shift in legal systems. The movement from status to contract is another way of saying this. The idea that each individual, as an individual, by their birth, has intrinsic rights to appeal to the law is of revolutionary importance. It's implicit in the famous declaration, American Declaration, we hold these truths to be self-evident, that man is born free and equal. Now, they may have pretended that they thought, Jefferson and others may have pretended they thought it was self-evident. It wasn't at all self-evident. No one in the world believed it except a few Americans in the New World and some Englishmen at that time. It was completely unself-evident. But it is a revolutionary concept which has now become widespread. As Maine himself wrote about the unusual and minority view, if I had to state what for the moment is the greatest change which has come over the people of India, and the change which has added most seriously to the difficulty of governing them, I would say that it was the growth on all sides of the sense of individual legal right, of a right not vested in the total group, but in the particular member of it aggrieved, who has become conscious that he may call in the arm of the state to force his neighbours to obey the ascertained rule. This is in his book on communities, page 73. This is not just confined to India, but is illustrated wherever British law was introduced in Africa or elsewhere. As the sociologist Bottomore, B-O-T-T-O-M-O-R-E, writes, one general tendency of legislation has been to extend the legal rights of the individual. For example, the right to retain personal earnings by the Gains of Learning Act, 1930, and the right of women to share in the property of the joint family by the Hindu Law of Inheritance Amendment Act, 1929, and the Hindu Woman's Right to Property Act of 1937. The British kept enacting laws which gave women, children, and others rights. And these rights extend further and further. You start with obvious things like women then children, and then animals, and then presumably plants and everything else. Almost anything has innate rights to be considered as having various things which you cannot do to it. The ancient English concept that every man has his own special piece, and if you break that you injure him, which is taken, that's a quote from Maitland, that you are, in a sense, every person in an individualistic society is surrounded by a shield, and if you violate that, you are violating something intrinsic inside them. Is extended widely. Current protests by East Asian countries about linking foreign aid to Western concepts of human rights is a recent example of this tension. The whole trouble that's going on now about Beijing Olympics and so on, is related to this. The Western concept of individuals having rights which you must not infringe, the right to free speech, the right to do this, the right to do that, comes into clashes seriously with societies which don't believe that. They believe much more in responsibilities and in group membership and so on. Finally, the premise of this is that law is uniform in various one. There is one law for everybody. You don't make special laws for special groups. This discussion that's been going on due to the Archbishop of Canterbury's remarks that there might be subgroups or subparts of our legal system separated off from the main legal system, practicing, say, Sharia law or some other, goes against this whole tendency. There are very few exceptional cases where you can apply a different kind of legal system. So there should be uniformity of law and uniformity in space as well. In many traditional societies, the laws and customs vary over very short distances. Every village and certainly every region has its own legal system. For example, in traditional France up till the end of the 19th century, each part of France had different legal customs and traditions. The oddness of England, being an island and early unified, was that the legal system was uniform in England. There were minor customary differences in manners at the manorial level, at the lowest level, like whether the youngest son or the oldest son inherited or whatever. But basically, the law of England applied in Yorkshire or Kent or Cornwall or wherever it was exactly the same law. It was, you had circulating judges who went from place to place to place to make sure that the same legal system was being used. Whereas, usually, over a very short distance, it will vary. Regional variations should be ironed out. There should be a common law for everybody. And this again is why things like having certain areas which are off bounds, like Guantanamo and so on, violates this principle, because it suddenly makes legal peculiarities which go against the uniformity and equality of law. So that's that, and next week I'll go down to questions like juries and the way courts work and so on. Thank you very much.